All right, Ms. Dukes McCoy, are you able to hear me okay?
Yes, Your Honor, can you hear us?
I can, thank you. We'll go on the record now in Hostman versus Buell. This is case number 2419716. The record should reflect that the plaintiff, Ms. Hostman, is present today by video along with her attorney, Ms. Dukes McCoy. This hearing was set for 2 o'clock. It's now shortly after 2. Mr. Buell has not appeared, nor has anyone on his behalf. This is set today for entry of a default judgment. Ms. Dukes McCoy, anything that you wanted to state for the record in support of your motion?
No, Your Honor, I think the motion speaks for itself. But I guess just for the record, we did file a complaint to quiet title. We did obtain a default judgment against Mr. Buell back in August. We've had no response, no contact from him whatsoever. And so we would ask that the court enter a default judgment in favor of Ms. Hostman today, quieting title to the property.
All right, thank you. I did have a chance to review the file prior to today's hearing. The plaintiff did perfect service of the summons and complaint by alternate service. There wasn't any answer or any appearance or attempt to defend on behalf of Mr. Buell or anyone on his behalf. The court's reviewed the proposed judgment and order quieting title. The court finds that it would be appropriate given the nature of the claims, so the court will sign that with today's date. Ms. Dukes McCoy, anything else that I can address for your side while we're on the record here today?
No, Your Honor, thank you.
Okay, thank you. I've signed that judgment and you're free to disconnect at this time.
Okay, thank you, Your Honor.
Right, looks like we have council connected. Mr. Blumberg or Ms. Mott, are either of you expecting someone named Loretta to be joining into this hearing?
No.
No, Judge.
Okay, all right, we'll go on the record then. This is case number 2419731, Eve Greif versus Advanced Electric. If I could have both counsel put your appearances on, starting with plaintiff.
Good afternoon, Your Honor. Elliot Blumberg on behalf of the plaintiff who's appearing via Zoom from my office.
Catherine Mott on behalf of Defendant, Advanced Electric.
All right, thank you. We're on the record here today for purposes of a scheduling conference. Mr. Blumberg, can you just kind of give me an outline of your claims in this case and what you would like to see for scheduling going forward?
Sure, Your Honor. My client was an employee of the defendant for over 20 years. She left and had made a bunch of sales and commissions that she's earned that she has not yet been paid for. So one would think that this, through discovery, we could resolve this matter, but I'm thinking maybe 90 to 120 days for discovery and mediation.
Okay. Ms. Mott?
Yes, Your Honor. We also have a counterclaim dealing with some personal property, a cell phone, and some other electronics. And my client's position is that they've already paid her in full. I'm fine with Mr. Elliott's proposal of 90 to 100 days.
Okay, and do you have any objection to having mediation within that period of time?
Nope, that sounds good.
Okay. And then, go ahead.
I was just going to say, she doesn't have to call me Mr. Elliott. That.
Oh, sorry. Apology.
No, that's fine. It's more respect than I get in my office. So.
All right, so the court will set this for a period of 120 days discovery. The parties to participate in mediation within that period of time. Mr. Blumberg, do you want to have this an attorney mediator, or do you want to go through community? What are your thoughts on that?
I think an attorney mediator would probably be helpful in resolving this.
Okay, Ms. Mott, do you have any objection to that?
I think it's such a low dollar case from our position that I would prefer community mediation, but I'm sure Mr. Blumberg and I could work that out.
Okay. All right, and then is there any objection to setting a dispositive motion cutoff for 30 days after the close of discovery?
I don't see any problem with that.
That's fine.
Okay. All right. Mr. Blumberg, any other dates that I can address for your side in terms of scheduling today?
Geez, Judge, I don't think so. That should be fine.
Ms. Mott?
No, thank you.
Okay, so I'll put all those dates into an order. I'll get that out to the parties. The court will also set this for a status conference following the close of discovery so that we do have a next date out there. And we'll go from there. Thank you. All parties are free to disconnect.
Thank you.
Thank you.
Hi, can you tell me what case you're calling in on?
Loretta Mogenberg. It's a divorce.
Okay, got it. Okay, I have that set for 2:30, so I'm just gonna put you on hold for just a little bit and we'll call your case
Okay.
at that time.
Okay, thank you.
Thank you. Okay, looks like we have both counsel connected. We'll go on record in Cruz versus Cruz. This is case number 2319351. We have Mr. Blumberg present on behalf of the plaintiff, and Ms. Manning's here on behalf of the defendant, Ms. Cruz. I'm a little bit confused as to what we're here for today. I thought we did take proofs and that the parties settled this matter. But Ms. Manning, this is your motion to settle the judgment. Is there an issue that's arisen between the parties as to the terms of the divorce?
Your Honor, I don't believe that there has been any issues that arose. There just has not been a judgment of divorce that has been signed. It's my understanding, and Ms. Conklin had started this process, so I'm kind of picking up where she left off. But it's my understanding that the parties mediated, I have it up on my screen here. It's dated January 26th of 2024. And since then, up until September, when I had drafted the judgment of divorce, there was not a judgment. Well, there was a draft judgment that Mr. Blumberg had sent over that did not match the settlement agreement or the mediation agreement. And that was, I don't recall when that was a while ago. June, maybe May or June. And so what I did was I drafted a judgment of divorce essentially with the terms directly from the mediation agreement, just to get a judgment of divorce entered, because this has been going on for so long.
All right, thank you, Mr. Blumberg.
Judge, an issue has arisen, and that's why there has not been a judgment entered yet. The terms of the mediation agreement are not in dispute. There is an issue as it relates to the defendant's award of a portion of my client's military pension. The years of accredited service has not been yet agreed to by the parties. That would determine what portion, if any, of that pension the defendant is entitled to. So that's why the judgment hasn't been signed. I have not had a single discussion with counsel about this. I wasn't aware that Ms. Conklin was not taking the file over again. She had been the attorney from inception. But that's the issue that needs to be resolved. And I'm not sure that that's an issue that we have to bring before you. Ultimately, it's really a factual dispute as to what years of accredited service occurred during the course of the marriage that would determine what portion, if any, Mrs. Cruz would be entitled to.
All right, so are you suggesting that we just, that you and counsel attempt to reach a resolution of this, and then to the extent that you can, we would set it for hearing before the court?
Yeah, I mean, I think that's exactly what needs to happen, frankly. You know, again, I do some military cases over the years, but what constitutes accredited military service credit is something that's really a term of art. And, you know, I think that once we get the documentation that shows the years of accredited service while the parties were married, that should really simply resolve the issue.
Okay, Ms. Manning?
I guess my issue with that is this is well, I shouldn't say it's the first. It was relayed to Ms. Conklin back in, like I said, June or July by email, and she had passed that along to me. But I have not had any contact with Mr. Blumberg. We sent the notice in September in anticipation of a hearing in September, and I had not heard from Mr. Blumberg, and I have not received any communication from Ms. Conklin from Mr. Blumberg. I mean, at this point, this has been, they mediated in January, I'm assuming. I don't want this to go on longer than it already has. I mean, I understand where Mr. Blumberg is coming from in terms of the accredited service timeframe. But I do have an issue with prolonging this since this has been going on for so long.
All right, well, I guess here's my question. So, Mr. Blumberg, I'm just looking at the mediation agreement. Hold on a second, I gotta. All right, so this is the mediation agreement from January 26th, and it reflects at paragraph 7 that the defendant is awarded, Ms. Cruz is awarded $1,000, some certain with cost of living increases from plaintiff's military pension. Plaintiff is awarded the remainder of his military pension. So what, based on what you're saying, where's the dispute or the discrepancy?
The mediation agreement and, well, what we anticipated is that $1,000 award was based on accredited service that had in fact been earned during the marriage. My client, who's now in Afghanistan, has indicated to me that while that was the agreement of the parties, it was based on information that he believes to be inaccurate. So, and while I'm not seeking relief to set the mediation agreement aside, I just am a bit leery to sign a judgment of divorce that awards a fixed amount of money for services that may not have been earned during the marriage. I'm not sure if I'm articulating that in a way that it's understandable.
Yeah, I mean, I get where you're coming from. I guess my question is, if Ms. Manning and her client aren't willing to change what is in that mediation agreement, then I think, you're at a point where you do have to ask to have that set aside. I mean, Ms. Manning's drafted judgment is quoted verbatim from paragraph 7 of the mediation agreement. So if you're saying that your client agreed to that based on, some kind of mistake of fact or something else, then I think you've got to file some type of motion to get him out from underneath paragraph 7, because it says what it says, and the proposed judgment is quoted verbatim.
I don't disagree with you, Judge. I mean, I'm not in any way suggesting that what was the judgment erroneously reflects what the parties agreed. It does. My point is that based on information that has been recently provided to me, there is a potential issue. And again, if my client is wrong about that, then certainly we can't and won't oppose the entry of the judgment. The problem I have, he's in Afghanistan, so the ability to communicate with him is somewhat troubling. But I would think that I'd go so far as to say that if we don't have the basis to get relief from the mediation agreement in the next 14 days, then the judgment can enter.
All right, Ms. Manning, what's your position on that?
I don't think that I have a problem waiting another 14 days to get confirmation of whether or not the contents of the mediation agreement are accurate. Like I said, and I, in general, would not have an issue working with Mr. Blumberg. However, like I said earlier, I've not received any communication from him saying that he's waiting on anything. I would have been more than happy to speak with him and discuss the issues. So I'm a little bit concerned that, at this point, I don't know if they're trying to just push this out and put off having to pay her spousal support. I'm not sure what they're trying to do. But I mean, I would ask that if nothing is done within 14 days, that, like I said, at minimum, that this is signed and done and over with. My client has been very patient trying to, find out what's going on, and I've not been able to answer her. Ms. Conklin had not been able to answer her. So we would just ask that this judgment be signed as soon as possible. I understand that working with the military and trying to get information from the military can be difficult, but like I said, we have not heard anything. We have not been asked to readdress anything. So we're just asking that the judgment be entered.
All right. So, again, I've reviewed the proposed judgment submitted by Ms. Manning. It does reflect the agreement as written in the mediation agreement that was entered into by the parties. Mr. Blumberg, I mean, in the interest of justice, the court will allow 14 additional days to the extent that you're going to file something to invalidate that mediation agreement. The court will give you a very short period of time. This case has been pending for a while, as has this motion. And as it stands now, I can't see any reason why the court should not enter that judgment, because it does accurately reflect the agreement of the parties. But again, to avoid more prolonged litigation, if the court enters it today, the court will give you 14 days again. If there isn't anything filed to invalidate that mediation agreement, then the court will enter the judgment as submitted by Ms. Mann.
That's very satisfactory. Thank you.
All right,
Thank you.
That's all for this hearing today, and all parties are free to disconnect at this time.
Thank you, Your Honor.
Okay, Ms. Mogenberg, are you able to hear me okay?
Yes.
Okay, we're on the record now in Mogenberg versus Mogenberg, case number 2419754. The record should reflect that Loretta Mogenberg is present here today by Zoom video. This hearing was set for 2:30. It's now 2:43. Amber Mogenberg has not appeared. Have you had any contact with her recently?
I have not. I didn't know that she wasn't going to be on this.
All right, she was the filing party in this case. Did you want to proceed with the divorce?
Yes, I do.
Okay. Are there any issues regarding the division of any assets or debts of the marriage that need to be addressed at this point?
No, nothing at all. We have nothing, no ties, no nothing.
Okay. All right. So first of all, the court notes based on the Amber did receive notice of the date and time of today's hearing about 30 days ago. Again, she hasn't appeared, so the court is going to find that she's in default, which means that, ma'am, you can proceed with this on your own, even though you're not the plaintiff. The court can set this for a final hearing. There's a form that you're going to need to get, Ms. Mogenberg. It's called a judgment of divorce. You can find that form online. It's very easy to locate if you just do a search through Michigan Legal Help online.
Okay.
I'll need you to fill out that form and submit that to the clerk's office here at the courthouse in downtown Gaylord. And then the court will set this for a final hearing as long as you have that form, again, called the judgment of divorce, submitted prior to that final hearing. Then I can finalize the divorce for you on that date, okay?
Okay. Okay.
Do you have any questions about that?
No.
Okay, so again, I'll send you, or the court will send you a notice of the date and time of that final hearing. It'll
Okay.
be by Zoom. It'll be by Zoom, just like we're doing today. Just make sure that you get that judgment form, fill that out and submit it prior to that date, and we'll go forward then, okay?
All right. Thank you so much.
All right, thank you, and you're free to disconnect at this time.
All right. Thank you. Bye-bye.
All right, I see both council are connected. We'll go on the record in Hammer Equipment Finance Incorporated versus Jacob Stuckman, case number 2419661. If I could just have council put your appearances on, please.
Yes, Craig Mears on behalf of Amore Equipment Finance.
Excuse me, Mark Dundon on behalf of defendant Jacob Stuckman, Your Honor.
All right, this is set for a motion on plaintiff's, a hearing on plaintiff's motion for summary disposition today. Prior to the hearing, the court did receive some documentation here in the file about a bankruptcy filing. Mr. Mirza, have you had a chance to talk to Mr. Dundon about that aspect of this?
Yes, I have, Your Honor. And last week, a week ago today, I submitted a proposed administrative order closing the case while the bankruptcy is pending.
Okay. And it maybe we just haven't received that yet. Mr. Dundon, is there anything that you need to add to that?
Not at all. That's what I was informed. Mr. Mearswood told me that makes sense. Sounds like, my guess is you're correct. It must have just not gotten there yet in the mail, Judge.
All right, so once the court receives that, the court will sign that order. I generally set these kind of cases just as for a control date status conference. So I'll set this for that at about the 180-day mark. If something happens prior to that, of course, then we can proceed with the case. Otherwise, that gives us the next date on the calendar to at least check in and see where things are at. Mr. Mirza, anything else I can address for your side today?
No, that's all, Your Honor. I appreciate that. And if in fact Mr. Stuckman's if his plan is confirmed, we can let the court know. And if the case doesn't go forward for some reason or it's dismissed, then we have the control date, and we'll certainly apply to the court to reopen the case in the event that happens.
Okay, thank
Sounds
you,
fair to
Mr.
me,
Dunn.
Judge.
Okay. All right,
Yes,
very good. Thank you. That's all for today, and you're both free to disconnect at this time.
Thank you, Your Honor.
Judge.
Thanks, Craig.
Take care, Mark. Yep, thank you.
Thanks.
We just got the order today.
Oh. All right, Mr. Lang, are you able to hear me okay?
Yes, good afternoon, Judge.
Okay, good afternoon. All right, and sir, on Christian's iPhone, can you tell me your name, please?
My name is Christian Cuello.
Okay. This is Johnson Oil Company versus Leo Distribution Incorporated and Christian Cuello, case number 2419792. The record should reflect Mr. Lang's here on behalf of Johnson Oil, and Mr. Cuello is here on his own behalf. This is set for a scheduling conference in this case today. Mr. Lang, on behalf of plaintiff, can you kind of tell me where things are at, what your claims are, and what you'd like to see for scheduling going forward?
Yeah, sure, Judge. So this is a pretty straightforward account claim. There's principal and service charges due of $116,000. My understanding is Mr. Cuello was involved in some type of delivery service that ended in 2022 while still owing a debt to Johnson Oil. Mr. Cuello did reach out to me. I just tried to text him. He left me with a settlement offer that I'll communicate to my client. So hopefully we can get something worked out. You know, I guess not knowing whether that will be the case or not, I would just request some short period for discovery, like 3 months. I don't think there's really any factual disputes that would warrant much work. I probably would like to get some requests to admit out. We did notice, and I don't know if it was Christian or his wife or partner had filed the answer, and an attorney was not retained by the entity. So we do have a pending motion to strike the answer of the corporate defendant and enter default. And you know, that's not set till November. So maybe before then we can have an update to the court about whether we've been able to resolve this.
All right, thank you. Mr. Cuello, anything that you wanted to say regarding what Mr. Lang has indicated?
No, sir. I did let Mr. Lang know. I've been trying to work. Can you hear me? Okay.
Yes.
Okay. I've been trying to resolve this for quite some time. I had been in contact with Johnson Oil and Mr. Johnson, and I had tried to kind of let him know, you know, where I was at. This has been ongoing, as you know, since 2022, when business went under. And I did have a partner, and we were supposed to be 50-50. Unfortunately, I don't know where he is. I don't know if he just disappeared off the face of the earth on my end, and never heard from him back. And so, you know, I just took on the responsibility of all this debt that the business had. And, you know, now I just work a regular job. I just drive a truck, and I don't make, you know, not that I was making that kind of money with the delivery business anyway. But I just don't make that money. And when I had originally spoke with Johnson Oil about kind of trying to resolve this, in, you know, I guess I was just looking in my best interest, in the way that I could still, you know, survive and feed my family, and also give them a little bit of chunk of money a month. I was told that I needed to put a kind of a larger down payment down, and I just didn't have that kind of money, and I still don't.
Okay. All right. Well, I think for purposes of going forward here, Mr. Lang, you said you already had a hearing date for your motion in November.
I believe that's correct, Your Honor.
Okay. So at this point, I'm not going to set a lot of dates going forward. I'm just going to have discovery remain open, just kind of open-ended at this point. I'm not going to set a cutoff for that. I don't think that's necessary given the current status. I'd like to have that hearing occur in November and see where we're at overall with the case at that time, and then do some further scheduling after that November hearing or at that November hearing, and go from there. Mr. Lang, do you have any objection to that?
No, that sounds fine. And Judge, I was able to locate and just pull up the notice of hearing. It's Monday, November 4th. And then I would just request, Mr. Quello, if you could confirm to me that you got my text to you. And then let's try to communicate over the next couple weeks and see if we can't figure something out. That would be helpful.
Yes, sir. Sounds great. That works with me. I will tell you, I am across state lines. So sometimes I have terrible service and sometimes it comes in and out. But I will get with you the moment I see it come through and let you know that I do see what you've sent me and try to proceed forward with you.
I appreciate that. And you might send me your email address as well in a
Not a
text.
problem.
Okay. Sorry, Judge. I just want to make sure we keep the lines of communication open.
Yep, no, I think that's helpful for everybody, including the court, so I have no issue with that. Okay, so we'll go forward in November. I'm gonna send out an order out of today's hearing, just indicating that discovery is to remain open. We'll proceed with the hearing in November and conduct further scheduling at that time. And all parties on this case are free to disconnect.
Great.
Thank you, Judge.
Thank you very much, Judge. Have a good afternoon.
And thank you, Mr. Lang. Appreciate it.
Okay, looks like we have everybody connected, so we'll go on the record. This is Cole versus Secretary of State, case number 2419837. If I could have counsel put your appearances on, please.
Thank you, Your Honor. For the record, on behalf of the Secretary of State, Mike Rolla from the Otsego County Prosecutor's Office.
Good afternoon, Judge John Steffi, P83203, Harris Law. On behalf of Mr. Cole, we're both here via Zoom today.
All right, thank you. Mr. Steffi, this is your client's petition for a restricted license due to a hardship exemption under a first implied consent suspension. I did have a chance to review your petition, Mr. Steffi. At these hearings, I typically have the petitioner, either himself or through counsel, proceed first with why the court should grant the restricted license, and then I'll give Mr. Roll an opportunity to state his position from the state. So again, Mr. Steffi, I usually leave it up to counsel whether counsel wants to address the argument or whether they want to have their client make statements as well. So I'll leave that up to you.
Thanks, Your Honor. I typically put on my client for a brief conversation, if that's all right with Your Honor.
Yeah, please proceed.
Great. Okay, Benoist, can you hear me?
Yes, sir.
Okay. Just going to ask you some questions. The judge knows a lot of this information already, but can you introduce yourself to the court?
My name is Benoist Cole.
Okay. Benoist, where do you live?
I'm currently staying at my aunt's house.
Okay. And is that where is that, sir?
That's in Petoskey, Michigan.
Okay. Previous to your license being revoked, were you living in Gaylord?
Yes, sir.
Okay. And Benoist, what do you do for work?
I own a bounce house rental company.
Okay, what's that called?
It's called Jumping for Joy Party Rental.
All right. Do you have any kids, Benoist?
Yes, sir. I have two. That's under the household with me.
Okay. And do you recall that we had a hearing on Zoom or Teams actually with the Secretary of State?
Yes, sir.
Okay. And was that in July of this year?
Yes, sir.
And what was the result of that hearing?
They took my license for a year.
Okay. So is it fair to say it's been almost 3 months since you've had a driver's license?
Yes, sir.
Okay. So one of our requests here is for a restricted license from the court. So I'd like you to explain why does your job require you to drive?
Well, I'm the owner of Jumping for Joy, and I do probably 98% of the labor within Jumping for Joy, and that entails me cleaning, delivering, prepping them. We also do concessions, tables and chairs, and I travel throughout northern Michigan with them.
Okay. Is this a year-round business?
It has been in Gaylord because they let us use the Civic Center for jobs as well throughout in the wintertime when it slowed down. It kind of slowed down a little bit after Halloween.
Okay. And does your family rely on your income to support themselves?
Yes, sir.
Okay. Besides your job at Jumping for Joy, do you need your license for any family duties or things like that?
Yes, sir. I do. I got a son in soccer. He's actually my stepson, and he also got basketball coming up. And then I have my junior, which is Benoist Jr. He has daycare. And yeah.
I think your older child is 10, is that correct?
Yes, sir.
Okay. And how does he get to and from school?
We normally give him a ride to school during the day.
Okay.
Yep.
And does your 3-year-old Benoist Jr., does he require transportation as well?
Oh yeah, we gave him a ride also to and from the daycare.
Okay. Anyone else in your family depending on you for help or assistance?
Yeah, I help my aunt out a lot who lives over actually I'm living with her now, but she's in Petoskey.
Okay.
Yeah. And she's I think she's 66 years old. So she kind of handicapped on one side due to a stroke a few years back. So I help her with a lot of stuff as well.
Okay, a lot of stuff. So prior to losing your ability to drive, what kind of stuff did you do to help out your aunt?
She definitely uses me to clean her car when she wants to drive. I do grocery shopping with her here and there. And I mean, obviously I live with her right now, so she don't need me as much to obviously to travel. But
Yes.
if it was ever a case that she needed me to and from a doctor's appointment or therapy due to her handicap, and I help her with that. But
And Benoist, is it true that if you were able to find something like a taxi, that's not going to really help you transport or set up a bounce house? Is that fair to say?
oh yeah, that's 100% accurate.
Okay, thank you. Nothing further, Judge. Thanks.
All right, thank you. I don't have any additional questions. I think Mr. Steffi, I think you covered all the relevant issues. Mr. Rolla, do the people take any position on the petition here?
Well, actually, Judge, I'm a bit perplexed, and unless I'm mistaken, looking at the file notes, I see this gentleman has 3 current pending matters scheduled. We have a plea set for the 21st of this month, and those charges involve felony controlled substance charges, resisting and obstructing charges, fleeing and eluding charges, and domestic violence charges. So I quite frankly don't understand the point in having the court issue a petition to grant driving privileges when the court's going to have to revoke them, and the Secretary of State's going to have to revoke them, even were they granted today in what, 2 weeks' time?
So, Judge, he's set to plead on this file. The plea is to a simple possession of cocaine, OWI first offense, and 1 count of resisting obstructing. There's no fleeing and eluding in this case. He has another file that's being handled by a court-appointed attorney that's being set for a plea. I don't know if that's on the same date or not, but the R&Os are all dismissed in that plea resolution. Ms. Roll is correct. If, with the plea to OWI first offense, there's a 30-day Secretary of State suspension that comes with that automatically. So obviously, that's a factor, but after that suspension, a restricted license would be very helpful to Mr. Cole, obviously. Prior to this year, Benoist did not have any involvement in the criminal justice system since 2012. So he's had a bad period of time here in the past few months that we're talking about. But prior to that, he's been doing a really good job of being a father, a businessman, and a law-abiding citizen. So it would be a big help to his family to have him working and supporting them. Thanks.
All right, thank you. Again, I did have an opportunity to review the petition prior to the hearing today. I've had a chance to hear from both the attorneys and of course, Mr. Cole as well. In these kind of cases, the court's put in the position of balancing the hardship of the individual involved in having their license suspended. And in particular, under circumstances where they elect not to take a chemical test and then so they're suspended automatically because of that. The court has to balance that hardship with the potential danger to the community if the individual is granted even a restricted license. In most cases where I have a petition like this, it's really just one charge, usually involves operating while intoxicated charge, but no other charges. In this case, the court has significant concerns given the nature and extent of the other charges that have arisen along with the operating while intoxicated offense. And given the nature of those charges involving assaultive behavior, both domestic violence that Mr. Rolla indicated, as well as resisting and obstructing police officers. One charge, although ultimately it sounds like the plea will be to a straight possession, a charge of possession with intent to distribute controlled substances, in particular cocaine. All of those things give the court some significant concerns about public safety if Mr. Cole is granted a license in relation to the hardship. And in my view, the court finds that the balance in that circumstance weighs in favor of issues of public safety. And the court is not convinced that any hardship that Mr. Cole may face not having a license is outweighed by, again, the danger to the public if he is granted even a restricted license. So
Judge,
for those reasons,
I'm sorry, Judge. Could I speak to the facts of the R&O count in this case? We obviously haven't put our factual basis on because we have the plea in a few weeks, but the R&O in that case was refusing to comply with the chemical test procedures. So it was not it wasn't an active strike at an officer. Wasn't something like that. He was just totally refusing the chemical test, and that's the facts of this case. And the other file, all those counts, to my understanding, are being dismissed as part of the plea agreement.
yep, and I understand that may be the factual basis, and I understand the dismissal pursuant to a plea agreement. I don't think that the court has to limit its consideration to charges that Mr. Cole is actually going to plead guilty to. I think the court has to look at the totality of the circumstances, and given that totality, again, the court finds that the interest of the public in not having Mr. Cole being able to drive outweighs the burden to him. So again, the court's going to deny the petition. And Mr. Steffi, I'm not sure if an order was submitted to the court, but if not, I'll ask you to submit the form order that reflects the ruling of the court here today.
Okay, thank you.
Okay, thank you. That's all for today. All parties are free to disconnect on this file.
All right, thank you.
Thank you.
All right, Mr. Eagleson, are you there?
I am, Your Honor.
Okay, all right, we'll go on the record now. This is Mullen and Koshara versus Brzezinski, case number 21-18497. We have both counsel present today by Zoom, and we're on the record here for a hearing, hopefully to put this matter to rest. Mr. Carey, I did receive your motion. I also received your response, Mr. Ingleson. And so, Mr. Carey, I guess I'm curious as to what, kind of your reply would be to Mr. Ingleson's filing. And I just want to tell you how I'm looking at this, and that way you can kind of correct me if I'm looking at this the wrong way. But it seems like the big sticking point is this paragraph about whether or not the line should be parallel. And Mr. Ingleson's saying that the way that your clients or that you're looking at it, it ends up not being parallel, and his clients lose about a little over a foot of property. I looked at the language, it says parallel. So my initial thought is, if it says it's parallel, then why don't we just use numbers that make it parallel? Because that's, to me, seems like that's what the parties intended. So tell me why we.
I think Your Honor and Mr. Ingleson and I are now all in agreement as to what you just said. Mr. Ingleson put in the effort to come down to my office and meet with me. So we had the survey, the infamous November 4th, 2022 survey in front of us. He showed me what his client's concerns were. And I expressed to Mr. Ingleson my understanding for the first time, frankly, of what his client's concern was, is that at one end point, the distance was 6.14. At the other end point, the distance was 5.64. Shouldn't they both be the same? And what we came to an understanding on, I believe, and Mr. Ingleson will hopefully confirm this, is that when we drafted the settlement agreement, we used a spruce tree kind of as the fulcrum point for the line. And so the line does need to be adjusted, but this was Mr. Ingleson's term, and I liked it. He says it's a teeter-totter. In other words, both endpoints need to be adjusted, because the only distance we called out in the settlement agreement was at the fulcrum point. So while one end is going to get nominally wider, the other end is going to get nominally smaller. And that's what my understanding is. That's what we've agreed to. I think the new distance, for what it's worth, that we're going to use is 6.14, because that's the distance, that's the width of the so-called Mullen strip at the spruce tree. So Mr. Ingleson has engaged their surveyor to make that change. In the meantime, they've paid us. We've been paid in full, and I've agreed to sign a stipulation in order of dismissal of the case. And so I think that's how we're going to resolve this case. If I've said it correctly, Mr. Ingleson, and if the court will ratify our agreement, that's how I think we're ending this.
Thank you, Mr. Ingleson.
Yeah, being former grade schoolers, the teeter-totter was a good analogy, and we've agreed on that. I've talked to my client about it. She understands and agrees, and we communicated with the surveyor, and he'll make the adjustment, and whatever the distance is on each end, so it will happen. And yes, we agree that we've finally gotten to the end zone.
Okay. Mr. Carey, when can we expect to have that dismissal from your side?
Well, I was counting on the plaintiff preparing the stip and order of dismissal, and I'm waiting for it, and I will sign it the moment it arrives on my computer screen.
All right, Mr. Ingleson?
I'll have it to you by Wednesday.
Okay.
It may be in our file right now, Mr. Carey, and Your Honor, but I'll be sure and we'll get it over to you.
All right, thank you. Then the court isn't going to conduct any further hearings. What you both indicated makes sense to me after I had a chance to review what you both filed. And so the court will certainly sign that dismissal when it's presented. Mr. Carey, anything further we need to address today?
I sure hope not, Your Honor.
Mr. Ingleson?
All set, nothing else. Thank you.
All right, thank you both for your work in getting this wrapped up, and you're both free to disconnect.
All
Thank
right.
you, Your Honor. Thanks, Hap.
Take care. See you.
All right, court has one more in person hearing left today, but I'm going to go ahead and disconnect from Zoom.